Are the directives issued by the South African Human Rights Commission automatically binding? Well, according to one former judge, the answer is no. The Commission recently approached the court asking for its directives to be declared binding and legally enforceable. This morning, we'll look at whether the powers and responsibilities of Chapter 9 institutions are fully understood across the board. And to help us do that, let's bring in former Constitutional Court Justice Yacoob, who joins us via our video link this morning. And it's great to have you with us, Zach. Thanks very much indeed for your time. The backdrop of this discussion, or let me say, essentially the springboard upon which we're having this discussion, is a ruling given by the Mbombela High Court recently that essentially pushed back against an application by the Human Rights Commission to declare a blanket approach to all directives issued by the Human Rights Commission. Essentially, the Commission was asking the court to allow all of what the Human Rights Commission finds to be binding. The court has pushed back against that. Do you think they did the right thing?
There's no doubt that the court did the right thing. And for that, one needs to go back to the Constitution. They relied on the Nkandla case, the Human Rights Commission, in that case of theirs. And the Nkandla case, as you know, was about the public protector, and it was about government corruption and government fraud. Now, the public protector has the power to take remedial action. And that is what the public protector had done in the Nkandla case. The Human Rights Commission, for some reason which I find difficult to understand, decided to use that and say, in the same way as the public protector was authorized to take remedial action, they too must be able to give directions. But if you look at the Constitution, the Human Rights Commission does not have the power at all, either in terms of the act or anything at all, to give directions. It has the power to do a whole range of other things. Now, that doesn't mean that the Human Rights Commission is useless. It doesn't mean that it is toothless. There are things it can do, and if you want me to go there, I will. But what it can't do is direct people to do something, go to court and say, I told them to do this, they don't do it. Please ask them to do it.
Let's stay with this case, and we'll speak about what they can do in just a moment.
Right.
But the reason why the Commission, I understand, went to the Mbombela High Court in this case is because they had actually made adverse findings against a particular company there, and then later realized that nothing had been done. And so I guess part of the question here is, what can they do in that context where they feel ignored, essentially?
Oh, yeah, that's where I was going to go. So the first thing is they have lots of powers of investigation, which they did, and they realized that they came to the conclusion that the farmer had the duty to provide water. Now, the way to do it is not to issue a direction to the human rights, to the farmer rather, but to go to court, sue the farmer, but not on its own. It must sue the farmer, authorized by the occupiers to sue the farmer. So it's actually the occupiers suing the farmer, and the Human Rights Commission providing assistance to them to manage their case properly. So you will remember that the South African Jewish Board of Deputies complained about the conduct of a Mr. Masuku, who they said had said terrible things about Jews. Now, they didn't go to court themselves. They went to court on behalf of the South African Jewish Board of Deputies, who were the complainants. So what they should have done in this case, if they came to the conclusion that they have a case, is to have provided the occupiers with legal assistance. This means that we have not reached the end of the road here, because the court, as you have seen, has directed that certain other things that the Human Rights Commission has done are valid, which is that they can continue, they must manage the settlement negotiations, they must ensure that the parties, that is the occupiers and so on, liaise with each other and negotiate with each other and engage with each other to try and resolve the problem.
Yeah.
The next step would be, and the next step is quite a complicated one, and if they want legal advice, but I just want to inform the people, I'm not giving legal advice to the lawyers. The next step would be, if nothing works here, the problem is that the municipality and the farmer, there are two people who could be liable to supply water, more the municipality and less the farmer. So the Human Rights Commission could bring a case joining, against the farmer of course, but joining the municipality, saying, right, the municipality, you are supposed to provide the water.
Right.
One of you do it and make a settlement. And the court has given an order already in other kinds of cases where there were people occupying land owned by others. And what happened was that the municipality was joined, the national government was joined, the provincial government was joined, because the landowner wanted to evict the tenants. And what happened was that the court decided that they'll take, that the owner of the land is obliged to give them 6 months or a year or something longer to stay there. In the meantime, the municipality has that amount of time to provide the houses.
Okay.
So done right, the Human Rights Commission can do it right, and they have done it right before.
Got you. I wonder, though, what the thinking was for those who drafted our Constitution, that be the route to be taken by Chapter 9 institutions like the Human Rights Commission. Because in my mind, my untrained mind, dare I add, the effect at the end is the same, but the route you've just pointed out is a longer one. What was the logic behind that?
The logic behind that is very clear. Unless there are very exceptional circumstances, courts are the only institutions which can tell people what to do and to order them what to do. That is a very sane principle in the laws of every country. Otherwise, if you have too many organizations ordering people about, then it can become a problem. Of course, there are exceptions to this, and the exception in our Constitution is the exception that the public protector can do it in cases of government corruption. In other cases, if there is a dispute, you see, for example, if there's a dispute between you and me, and you owe me 100,000 rand, I can either kill you and take your money, which is taking the law into my own hand, or I go to court. Now, if the Human Rights Commission thinks that the farmer is obliged to provide water, it can't force the farmer to provide water. There's a difference of opinion about that. The farmer thinks it is not obliged to, he is not obliged to provide water. The Human Rights Commission, of course, thinks that the farmer is obliged to provide water. Now, who is going to decide the difference? The Human Rights Commission can't be the judge in its own cause, and therefore it must go to court to let the court decide who is right. As I say, there are some exceptions to this rule quite often, and the only exception that I've been able to come across in our Constitution is the exception of the public protector. And I think it is right, because if there is a dispute between two parties, even if one of them is a Human Rights Commission, about whether somebody is obliged to do something or not obliged to do something, it is absolutely right that the court should decide. Otherwise, you have absolute pandemonium and lack of order.
Fascinating. Great perspective that in a context where I think there were some people who are worried that what the High Court in Mbombela has done is in some way clip the wings of the Human Rights Commission. But as you've emphasized, what they've done is very much in line with our Constitution. Yacoob, thanks very much indeed for your time. Really do appreciate it today.